Motion carried. 4 ayes, 2 absent. So is there a motion for the revised rules of order? Member Blair, Member Bryant. So discussion, I'll repeat, as I said in executive committee. Um, I think many probably already thought the 30-minute rule was on committees, but after State Attorney Jenny reviewed the rules, there was no time limit in a committee structure for public comment. So we thought it would be wise to bring it back and actually clarify the basically the same rules that we have at a full board. 30 minutes divided by however many people, 5 minutes for per single person. If it's under, say, 2 people, that would be they would each get 5 minutes for a total of 10 minutes. But if there's more than that, it's divided to how many people want to speak. Plus, it does allow for the board to be flexible, and if they want to extend that, they can extend that. But we needed to have the actual rules and the language in place from the full board meeting into committee. So that is what is in front of us with consultation from the state's attorney's office. And if there's questions, I'm sure Jenny would be happy to answer them. Member Ruling?
Do committee public comments in turn limit those board comments at the next board meeting, similar to a zoning board where no new information can be presented? Now, obviously, that may or may not be true with the presenter, but if the same presenter shows up at both, are they limited to previous testimony?
So in case this is mostly would apply to, let's just say land use, when land use has hot topic issues off the bat. Typically, if there's multiple people that would want to speak in that, when I was chair of land use, I would always say at that, this is a public comment. You're free to say what you want. I'm reminding the board, though, that only thing that can be taken as evidence is what was submitted to the ZBA. So if anything is said here outside of what was permitted, and we typically ask the person if they actually spoke at the ZBA. And then we would typically also then have, that was when Kathy in the past or Andrew now would sit with the actual recordings and basically be giving a thumb up or thumb down whether or not that's new information or out of bounds information for the board. But it is a proper practice for specifically ZBA. Any other committee that can basically say, but with a ZBA land use, the board can only be taking the information as presented to the finders of fact. Correct?
Right. So the public comment, you can't necessarily limit what the person's going to say. It's exactly as Chairman Dillon explained it. It's really about then what the board member has to just, have the discipline to only consider and cast their vote in light of the actual evidence that was presented. And you're right, it only applies to ZBA. And that's because the ZBA is the finder of fact in that instance, and then land use and the county board voting to either approve or deny what the ZBA has done. It's almost like an appellate court scenario.
Understand. Thank you.
Other discussion? Good question, though, Member Ruler. Member Ruler?
Again, in this situation where with, say, land use, as we anticipate a permit application for a wind farm, it seems, at least perception-wise, that it might not look good for us to limit public comment at a committee meeting and then open it at a board meeting. So my gut tells me, as we anticipate more sensitive subjects, that the committee should hear or should be allowed to hear at least as much as what would be presented to the board or what could be the comments that could be made to a board. So if we have 30 minutes of public comment, limited to 2 minutes apiece or whatever our rule is on that, I would suggest that in the interest of fairness and hearing everybody, not just committee members or not just board members, hearing the same passion or comments or logic from the public, it strikes me as odd that we would allow any different amount of time. If we're going to have 30 minutes at the board, then we should allow 30 minutes at the committee level. That's just the first thing that comes to mind for me.
So that's what is being proposed. So you're in agreement with that?
Agreement.
Okay.
Yes.
So I do think when it comes to, as what you had said, that there will be discussions with an attorney per se of at the advice of our state's attorney and legal counsel, if there needs to be extended time depending based on how many, if we have 100 people per se sign. But what we've also done in the past, which has been few and far between, but we've collectively, if there had been an extended amount of applicants looking to speak, we've asked the opponents or proponents to consolidate some of their speeches so that we could have fair speaks or have representatives speak on behalf on that. And that system has worked fairly well in the past as well. So agreed that our board rules should reflect to what our committee rules say. Thank you, Member Rowland. Any other questions? Seeing none, please cast your vote.
All right. It works.
Okay. So that vote was for the actual resolution. Motion carries 4 ayes, 2 absent. That would bring us to public comments. Scott, anything you want to add? That would next bring us to miscellaneous. Thank you for the short notice of having this meeting. Appreciate it to the committee. With that, meeting adjourned. Still pretty good, 4:59.